I read every one.
He'll either need to come in and sign paperwork, or he'll have to have access to a fax machine and sign the paperwork. Otherwise, we can't release bond to apply towards this. So what I will do is I'll make a note that we're going to apply the bond with his permission. If that doesn't happen before the end of the week, we'll have to set you up on financial review hearings.
Okay.
All right.
Yes, sir.
You can stop out of the front window where you checked in and find out the process to have that released. Okay.
Yes, sir.
All right. Thank you.
Thank you.
Person at the jail, what is your name?
Anne Carlson.
This is case number 253910 FY, the people of the state of Michigan versus Lori Anne Carlson. We're here for an arraignment. Ma'am, is 16 and a half Road a good mailing address for you?
Yes.
And a phone number ending in 1007, is that a good number?
Yes. My
Did you have the
address
No, for a telephone number.
Yes, it is.
Did you have the opportunity to meet with somebody from the defender's office today?
Yes, but I'd like to talk to them again, please.
Well, I don't have time for that right now, so we'll start the arraignment and then we'll see where things get from there. So I have a complaint that alleges that on or about August 31st, 2025 in Greenwood Township of Wexford County, it is alleged in count number 1 that you committed the offense of controlled substance possession of methamphetamine or ecstasy, in particular methamphetamine. That is a felony punishable by up to 10 years in prison and or a fine of $15,000. Additionally, the prosecution has elected to charge you as a second or subsequent offender, which means that you have at least one prior drug conviction in your past. That brings that 10-year felony up to a 20-year felony and the $15,000 up to $30,000. Do you understand those charges and the potential penalties?
Yes.
On felony complaints, you have certain rights. You have the right to remain silent. Anything you say or write can and will be used against you. You also have the right to have an attorney present during any questioning that you consent to, and you have the right to stop answering questions at any time. You also have the right to be represented by an attorney. If you could not afford one, one would be appointed at a public expense, but you may be required to repay a portion of that expense. Do you understand that?
Yes.
Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
Appointed attorney.
All right. What is your current source of income?
I'm retired.
The court will make a referral to the public defender's office for the appointment of an attorney, enter a not guilty plea on your behalf, and will set the matter for a preliminary examination. That's a hearing that's held here in the district court within 21 days. At that hearing, the prosecution will be required to prove 2 things. 1, probable cause that the crime had occurred, and 2, probable cause that you were the person who had committed the offense. If the prosecution is not able to do that, the case would be dismissed. If they are able to do that, you'd be ordered to stand trial in circuit court. Prior to the preliminary examination, there'll be a probable cause conference. You also have the right to be the right to be considered for bond. Bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public. Counsel, I show that in 25, there was a use of methamphetamine. Our local records show in 22 a retail fraud 3rd, and in 91 an expired license. And it also appears that she is has a probation violation pending out of the 86th District Court. Any comment regarding, and the praxis scores her at a risk level 3. Any comment regarding bond defender's office?
Yes, Your Honor. She lives in Manton, which is relatively close. She's lived there for 30 years. Like she said, she's retired, but she also stated she does adult foster care, which is a good thing to do. She obviously sort of advanced in age, and it is adverse to her health to be in jail. I respect that she has or likely has a hold out of Traverse County, correct?
Grand Traverse, yeah.
Grand Traverse County. So in that case, I would ask for a low cash bond so that she can maintain jail credit. Thank you.
Thank you. Prosecutor's office?
Thank you, Your Honor. I did note it appears that there was an active warrant at the time of the arrest for a probation violation. So that does raise concerns about a flight issue. I do think some kind of cash bond is appropriate. And I'd also ask for random drug testing. Thank you.
Thank you. The bond was previously set at $35,000 over the weekend. Given that the defendant was on probation at the time for essentially the same type of case, although that was a use of meth, this is a possession of meth. The court believes that a monetary bond is appropriate. Bond will be set at $20,000 cash surety bond with the requirements of no drugs, no recreational marijuana, and random testing. Next arraignment.
All right, let's talk about that. This arraignment in front of Judge Corey J. Wiggins was a textbook example of how serious charges, past history, and bond arguments all come together in the first real look at a case. The defendant, Lori Anne Carlson, was facing a felony possession of methamphetamine charge, bumped up with a second offense enhancement that doubled the maximum penalty from 10 years to 20, and raised the possible fine from $15,000 to $30,000. Nence's demeanor was steady and professional throughout. He didn't rush, he carefully explained every right and potential consequence, and he made sure Carlson understood exactly where she stood. Carlson herself came across as polite but a little weary. She confirmed her address, gave her phone number, and admitted she was retired, supplementing her income with adult foster care work. When asked about an attorney, she quickly requested court-appointed counsel. Her responses were clear, and while her tone carried a touch of fatigue, she stayed cooperative. What stood out was her age and long ties to the community. She's lived in Manton for 30 years, and that background played into her defense's request for a lower bond. The pub's office argued that Carlson's age and health made jail especially difficult, and emphasized her community ties and caregiving role. The attorney respectfully acknowledged she likely had a probation hold in another county, but pushed for a low cash bond so she could at least maintain jail credit if she stayed held. It was a straightforward, sympathetic pitch. The prosecutor, by contrast, took a firmer stance. She pointed out that Carlson was on probation at the time of this arrest, with an active warrant for a violation, and that this charge mirrored her past issues, use of meth just a few years earlier. Her delivery was crisp and direct, flagging both the risk of flight and the pattern of continued behavior. Judge Wiggins listed IDs and then cut right to the core. He noted the prior probation violation, the fact that this was essentially the same type of case as before, and the seriousness of a repeat meth possession. His conclusion was clear. A monetary bond was appropriate. He set it at $20,000 cash or surety, down from the $35,000 originally set over the weekend, and added strict conditions: no drugs, no recreational marijuana, and random testing. The overall atmosphere of the HLM and orderly. Carlson wasn't combative. The attorneys were professional, and Judge Wiggins kept the tone measured, even while tightening the reins. It wasn't dramatic, but it was a strong reminder of how past conduct weighs heavily in bond decisions. Wiggins' style was firm but fair. He acknowledged Carlson's circumstances, but made clear that the court couldn't overlook the risks. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read everyone.